Welcome to Deloitte's Debrief Tax webcast series in Asia Pacific. Our webcast today is from our Geography Update series and is titled India's New Labour Codes Prepare for the Challenges Ahead. My name is Saraswati Kasturi Rangan and I'm a tax partner based in Deloitte India, Bangalore office. I have the pleasure of hosting today's webcast. I have three speakers with me today, Atul Mittal, Radhika Vishwanathan, and Anjali Malhotra from the India practice. Atul is a tax senior director based out of Delhi office. Radhika is a tax director based out of Chennai, and Anjali is a tax senior manager based in Delhi. You may access our bios on the left side of the screen. Before I introduce the agenda for today's webcast, I'd like to take a moment to highlight some of the features of our webcast console. First, all users are on listen-only mode. If you have any content-related questions, you can submit at any time in the Q&A box at the bottom right side of the screen. We'll do our best to respond to your questions during the presentation. Second, all PC users can maximize or minimize each box at your convenience during the webcast. You may also explore the icons at the bottom of the screen. If you want to download today's slides and the related publications, please go to the Downloads and Links box. Mobile device users can view the slides and answer the survey on the screen. Thirdly, if you require an attendance record for this event, you can download your CPE certificate by clicking the Request CPE icon at the bottom of the webcast console. Now, let me give you an overview of the topic that we will discuss in the next 1 hour. Our topic for today's session is India's new labour codes prepare for the challenges ahead. Over the past few years, ease of doing business is something that we in India have been constantly hearing. The government, with the objective of easing the multitude of challenges, has initiated various measures including rationalization of procedures, simplification of forms, digitization, unification of the portals, and so on. Well, these were focused on the operational aspects, and it's also been necessary to revamp the labor law regulations which have been in existence for over 50 years. There was clearly a need to realign the regulations with the current business requirements and the technology changes that are being adopted and help to minimize litigation. The consolidation of various central labor regulations is without doubt the need of the hour. While the seeds of this exercise were sown at the start of this millennium, we now have 4 labor codes, namely the Code on Wages, the Code on Social Security, the Industrial Relations Code, and the Occupational Safety, Health and Working Conditions Code. And these subsume 29 central labor laws that have received presidential assent. The draft rules under all the 4 codes are available in public domain now, and the issue of the finalized rules are expected very shortly. With this, things appear to be all set for the 1st April rollout of the codes. Over the next 45 to 50 minutes, we'll take a look at what's changing in the new codes, how and where it would impact the employees and the employers, the key aspects and implications of the new wage definition, how this could widen the coverage as also impact the quantum of contributions for retirals and the entitlements under the code. We'll also discuss the new categories of workforce that are intended to be brought within the Social Security ambit and the related obligations, consequences of default, and how entities are approaching the new code. And as we go along, please do share your questions in the Q&A box with respect to these provisions. So let us start from the beginning. Why at all consolidate? What was the need and what is the intended benefit? Well, here is a quick overview of the background to the legislation. Today, there are a multitude of regulations in India covering various aspects of labor compliance. Under each of these acts, we have various terms that are defined. such as who is an employer, who is an employee, what is an establishment, what is wage for the purpose of that particular regulation, and so on. And each of these are distinct and varied. The interpretations also differ since the object of each of these regulations is very different. The term wages, for instance, could either be interpreted very widely or narrowly depending on the base of the regulation. The regulations lay down the compliance as required, the forms and the filing requirement. Some of these are online and some of these are manual as well. The penalties are also very varied and the extent of litigation under many of these is very high. Well, the whole objective of the labor codes is therefore to consolidate the regulations, simplify the approach, enhance the ease of compliance and transparency using technology, and with seamless interface. Since all the four codes have received the presidential assent, they are acts as on today and are awaiting the notification of the effective date of operation. That is the date by which these codes will come into force. We do believe that the government is targeting 1st April as a likely date, but we'll have to wait and watch. Now, moving on to the next slide, here is a listing of the various legislations that will be subsumed once the code becomes effective. The Code on Wages, as you can see, consolidates 4 legislations relating to determining and payment of wages. These are the Payment of Wages Act, the Minimum Wages Act, the Payment of Bonus Act, and the Equal Remuneration Act. The Code on Social Security, as the name clearly suggests, subsumes 9 legislations providing social security in various forms such as Provident Fund, insurance, maternity benefit, compensation for employment-related accident injuries, besides the ones relating to the unorganized sector such as building workers' welfare, cine workers' welfare, and so on. The code also includes provisions relating to the Employment Exchanges Compulsory Notification of Vacancies Act 1959, and this is something companies really need to watch out for. In the draft rules issued last year, we saw a chapter on the employment information and monitoring, which indicates that employers in the private sector with 50 or more employees, or maybe as notified by the central government, are required to report vacancies to the regional career centers in the prescribed manner. While we are waiting for the final rules, in the draft rules, the timeline indicates that the reporting has to be at least 15 days before the last date of receiving the application from the prospective candidates. Clearly, there is going to be a change in the recruitment process that companies follow. Going on to the next slide, the Industrial Relations Code amalgamates 3 legislations, the Trade Unions Act, the Industrial Employment Standing Orders Act, and the Industrial Disputes Act. And these deal with the procedures relating to industrial operations, disputes, and so on. The Occupational Safety, Health and Working Conditions Code subsumes 13 statutes, the largest in the consolidation exercise. And it subsumes the Factories Act, the Mines Act, the Contract Labor Regulation and Enforcement Act, and so on. As you can see, this code subsumes legislations relating to various domains, and it includes the unorganized sector as well. So with that background, and before we get on to the provisions, we have a question for you. The question is, what in your view would be the effect of changes in the labor codes to your business? And your options are financial impact, need for process change, realign salary structure, all the above, do not know, not applicable. And while we are waiting for the results to come out, let me turn to Atul. Atul, what would be your take on this and why?
Yeah, thank you, Saraswati. Looking at the provisions of all the 4 codes, we appreciate that the consequences of changes are all encompassing and far reaching. While there is a significant change in the various compliances that are required under the codes, there are implications from the financial perspective. mainly stemming from the change in the definition of the term wages, provision of the engagement of contract labor in core activities, notification for formulation of safety committee, appointment of safety officer, changes in overtime, etc., etc. These will trigger significant policy and procedural changes. Hence, I would say, Saraswati, that is the impact which is quite broad and would be having a far-reaching effect.
Okay, well, thanks, Atul. That actually turned out to be a high-level overview of the codes themselves. And I think we can see the response from our participants also indicates that 77% of them believe that it's going to be all of the above in terms of financial implications, need for process change, realigning salary structure. So I think, yes, we are in for interesting times. And with that, let me just pass on to Radhika. Radhika, can you please take us through the salient features of the Code on Wages and the Code on Social Security, please?
Sure, Saraswati, and a very good morning or afternoon to our participants, depending on which time zone you are in. One of the major distinguishing features of the Code on Wages is that it applies to all establishments, employers, and employees, unless a particular category is specifically exempted. Hence, it would not be an exaggeration if I say that the coverage has been widened. This would also mean that the code is applicable to managerial employees, and this could throw up some significant impact. Now, the term wages has been defined under Clause Y to Section 2 of Code on Wages. As you mentioned, Saraswati, for the first time, we have a uniform definition for the term wages. This definition would be applicable across all four codes with minor modifications where specified. In contrast to this, the subsumed legislations have their own definition for wages, such as one in the Minimum Wages Act, the Payment of Gratuity Act, the Payment of Bonus Act, and so on. Now, the minimum wages will be aligned to the floor wages that will be issued nationally by the central government. While state governments will have their own right to fix the floor rates for minimum wages, it cannot be less than the national floor wage that the central government notifies. Another important aspect is that employers need to ensure that wages are paid within the due dates for the relevant wage period. The maximum wage period cannot be longer than 1 month. In the case of a fortnightly wage period, payment has to be within 2 days from the end of the fortnight and within 7 days in case it is a monthly wage cycle. Timelines have been considerably shortened for settlement of employee dues on termination. We also need to bear in mind that this includes resignation. The code proposes a 2 working day settlement period. However, one can breathe a sigh of relief since the term used is settlement of wages rather than full and final settlement. Therefore, a view could be taken that this does not include the retiral benefits. Under the code, the quantum of penalty is also being significantly increased. Besides, authorities have substantial powers for prosecution too. Moving on to the Social Security Code. The scope here is also being expanded to include individuals on fixed-term employment contracts. Now, fixed-term employment is defined under the code to mean engagement of an employee for a fixed period of time on the basis of a written contract. FTEs shall be eligible for all benefits under the codes that are otherwise available to a permanent employee, though this will be on a proportionate basis, thereby triggering gratuity payouts for such employees upon exit. And the service period threshold of 5 years, as is relevant to regular employees, will not be applicable to this category. This is one area to look out for since businesses could be looking at substantial cost impact if they have this type of workforce. You'll have gig workers and platform workers being brought in within the Social Security ambit. When it comes to gig workers, the code defines them as those who do not enter into a formal employer-employee relationship, but still perform work for the entity and earn income from such work. Interestingly, the transition provisions under the Code of Social Security specifically indicates that the existing schemes relating to Provident Fund, ESI, Gratuity, these would continue to be valid for a period of 1 year from the date the code becomes effective. The need for new schemes to be notified before the government can announce the go-live date. Another important provision is with respect to introduction of the period of limitation. Now, under the current PF Act, as many of you here would be aware, there is no period of limitation, meaning the authorities can go back any length in time for audit or inquiry. However, under the Social Security Code, there is a 5-year limitation period that is being specified. So in this case, authorities cannot go back beyond 5 years. This brings about a level of certainty to the litigation aspect and therefore would be a welcome move. So let's now get on to an overview of the impacted areas. First and foremost would be the impact on account of the changed wage definition. While some of these could result in change in the quantum of entitlement, in other instances, the new definition can bring more employees or workers within the coverage of a certain provision. Now, illustratively, if you take the case of Provident Fund, we know that the quantum of contributions towards Provident Fund for domestic employees who draw salary less than the wage ceiling and for international workers will increase on account of the new wage definition. However, with respect to domestic employees, the terms of employment arrangement, the contract, the policies will also have to be examined, especially when they are earning more than 15,000 per month, so as to take a position on the potential impact. Another area that could be impacted would be on gratuity, and here it would be both on the entitlement as well as the coverage. Wages now includes bonus. Only statutory bonus is listed as an exclusion, and it also includes value of benefits in kind. Now, this would impact the gratuity liability of the company for the past service periods as well as impact the take-home of the employee, where gratuity is part of the CTC of the employee on a go-forward basis. Another issue is on hours of work beyond normal working hours. Here, they are entitled to overtime at double the wage. Given the wide definition of wages and the enhanced coverage, employers need to be mindful of the significant financial implications this would trigger. Now, those are the primary areas of impact under the Code on Wages and the Code on Social Security, in my understanding. I would pass it on to Atul to give us an overview of the Industrial Relations Code and the Operational Safety and Health and Working Conditions Codes, besides their key impact.
Thanks, Radhika, and very good morning to all the participants. Let me start the technical discussion with an overview of what the Industrial Relations Code and Occupational Safety, Health and Working Condition Code has in store for us. These codes are not mere consolidation of various subsumed regulations. There is a conscious widening of benefit under the code while focusing on simplification and rationalization of the procedural aspect as well. The applicability of the code has been extended to non-profit, to the establishments where even the capital has not been invested. The idea to regulate and maintain cordial relation between employer and worker, hence the applicability has been extended. Adoption of standing order is required by establishments having more than 300 workers, which currently this limit is 100. The draft standing order has been placed in the public domain, and now it has to be adopted by the establishment having more than 300 workers. A works committee is required to be constituted if ordered by appropriate government, be it a central or state government. A grievance redressal committee is also required to be set up so that the dispute could be amicably settled in time-bound manner. Certain activities have been called out as unfair labor practices, and one has to be mindful of these in the communication to the workers, trade union, etc. Companies need to be mindful that there will be additional financial implication in the situation of a retrenchment, in addition to the retrenched compensation payable, which is equivalent to the 15 days wages for each completed year of the services, payout toward reskilling fund is also required to be made. The employer is required to pay out 15 days wages to the reskilling fund, which will be maintained by the government fund, and government in turn has to pay this fund to the retrenched worker within 45 days from the date of retrenchment. Notice required for strike and lockout has been extended to all the establishment, which earlier used to be restricted to the public utility services. Earlier, prior approval of Government of India was required for any lockout, closure of industry or retrenchment where 100 or more workers were employed. Now this limit has been announced to 300 and more flexibility is provided to the employer. A new concept of negotiating union has been included, wherein one of the union having majority of the workers' representation shall be notified as a negotiating union. This will help in early settlement of dispute between the employer and worker through the mechanism of provided therein. Let's move on to the key provision of OSH code, which primarily governs the provision relating to health, safety, and working condition for the worker. It provides for unified registration under all the subsumed legislation. Single registration would suffice the compliance under new code. Keeping in view the health of the worker, the working hours have been reduced from 9 hours to 8 hours in a day with a spread of 48 hours over a week. The rest interval for half an hour is mandatory after 5 hours of work. There are certain compliances in relation to issuance of appointment letter, core activities, which we will deal in detail in next slides. The employer is now obligated to provide free health checkups for a prescribed industry. This benefit is required to be extended for interstate migrant worker as well. Employing women in certain industries was restricted earlier. Now that restriction has been done away and flexibility has been provided for employment of women in all type of industry across as well. However, employer has to take care of the safety of women and consent from the working woman is required. As a safety concern, the safety concern has been raised across the industry. It has been mandated to constitute safety committee in prescribed industry, and appointment of safety officer is required in prescribed industries to protect the interests of the worker employed therein. To regulate the governance of this code, even the National Occupational Safety and Health Advisory Board shall be constituted, which shall monitor the effective implementation of the code. Now, I would request my colleague Anjali to take you through some of the key impact area in detail under these codes. Anjali, over to you.
Thanks, Atul. I'm happy to share an overview of the key impact areas under the two codes. So, prohibition of engaging the contract labor in core activities is the first thing that I would like to highlight. Hence, companies would need to identify areas which can be considered as non-core and engage contract labor only in such areas. However, there are exceptions which has been provided by government in this regard, keeping in view the requirement of the industry. If the normal functioning of the establishment is such that the activity is ordinarily being done through the contractor, or if the activity is of such nature that it does not require the workers, full-time workers for the major portion of the working hours, or if there has been a sudden increase in the volume of the core activity, which need to be accomplished within the specified time, then the organizations may go ahead and engage the contract labor in the core activities. Else, they need to be mindful that permanent workers has to be engaged for carrying out the core activities. Another area of change is need to issue the appointment letters mandatory. Though as a customary practice, the appointment letters used to be issued to the employees, it is now mandatory to issue appointment letters to all the employees in the prescribed format. The requirement is to issue this document even to the existing employees where the letters are inconsistent with the format which is prescribed, and that has to be done within 3 months from the commencement of the code. Regarding the leave entitlement also, the time limit has been reduced to be eligible for the leave with wages from existing period of 240 days to 180 days. For the purpose of leave encashment, a worker shall be entitled on his demand for encashment of leave at the end of the calendar year. And where his leaves exceed 30 days, he shall be entitled to encash the exceeded leaves. The concept of reskilling fund, which Atul just now mentioned, that has already been discussed in detail and has an additional financial impact on the employer only in case of a retrenchment. Despite retaining the concept of a works committee, the new code also recognizes the concept of the recognized trade union. A trade union which has the formal support of 51% of the workers in an establishment will act as a negotiating union within the establishment to resolve the disputes. In case union fails to get 51% of their members as the support of the trade union, a negotiating council will be formed which will have a members representing all the trade unions having 20% or more of the workers. I would now request Radhika to take you through the wage definition and impact thereon. Radhika, over to you.
Thanks, Anjali. As we've been saying a few times over in this webcast, the definition of wages is uniform across the codes and will impact in the codes. The definition per se can be broken down into 4 buckets, as you can see in this slide. The inclusion part, some specific exclusions, limits on inclusions, and the benefits in kind. The inclusion part is absolutely wide. It starts with all remuneration, salaries, allowances, etc., or even otherwise provided in accordance with the terms of employment, be it expressed or implied. All of these are included. And there are 3 components which have been specifically listed, namely basic pay, dearness allowance, and retaining allowance, if any. So any component that is payable based on a contract of employment will fall under the definition of wages. However, we have a long list of exclusions, as you can see in the second column. Now, these include statutory bonus payable, value of house accommodation and utilities, employer contribution to provident fund or pension, conveyance allowance or value of traveling concession, sum paid to defray special expenses due to the nature of work, house rent allowance, remuneration payable under any award or settlement, any overtime allowance, or any commission paid. Now, all of these have been color-coded in blue, and there is a reason for that. All the above items are exclusions which are subject to a ceiling limit and can be excluded from wages only to the extent that their cumulative value does not exceed 50% of all remuneration. There are also exclusions which fall outside the ceiling limit. So any gratuity that is payable on termination, any retrenchment compensation or retirement benefit payable, or ex gratia payment will fall under this category. In respect of remuneration in kind, where an employee is given benefits in kind in lieu of either the whole or part of the wages that is payable to him, the value, as it does not exceed total wages payable to him, shall be deemed to form part of wages of such employee. Now, it is not clear how the benefits are to be valued. Say, for instance, if an employee is provided stock benefits, how the value of this component is to be determined is not indicated, though the ceiling has been provided. Another issue is in the case of even non-statutory bonuses, such as performance pay, incentives, or variable pay, typically these were always excluded from wages for most purposes. Here, however, there is no such specific exclusion. Listing out amounts paid to defray special expenses is also surprising. And the absence of illustration or examples on how this is to be applied in practice could also pose challenges given the varied salary structure that companies have. Now, that was the definition per se. When I see the definition, there are a few questions that pop up in my mind, and I'm sure it will be the same case with all of you here. These questions are how and where all of this is going to impact the entity. Would it be an additional cost to the employer? Is it going to impact the employee's take home? Will there be extensive realignment of policies and procedures that need to be done? Saraswati, can I request you to share your views on this?
Right, Radhika. I would really agree. And to put it in a nutshell, wages has been defined in a varied manner today under the various regulations. And the unified definition is actually changing things very significantly. And hence, there is a clear need for companies to map the definition of the wages to their specific salary structure. So go through the salary structure, identify the components of pay, map it to the definition of wages, and then look at what could be the impact. To my mind, and based on what we've seen, some of the areas of impact would clearly include increase in retirement benefits, say gratuity payouts, PF contribution. Again, we would need to look at it depending on the salary level of the employees. And these could actually result in a reduced take-home pay of the employees as well. And companies will also need to wait and watch on the approach the government would adopt with respect to one-time payouts and variable pay. But notwithstanding that, when we look at the impact analysis, we would also need to see whether there is going to be a change in coverage, say under the Payment of Bonus Act, from an ESI coverage perspective and so on. So that's what I wanted to share, Radhika. And I know no wages are going to be different when computed using the new definition. And hence the impact, it will really impact the benefit entitlement as well. And I thought it will be good to understand this better using an illustration. So it'll be great if you could take us through a couple of case studies, Radhika.
Sure, Saraswati. I'll be happy to explain using a couple of examples. First up, on computing wages itself using the definition. So in this slide, we have taken a structure, a very simple structure comprising basic salary, HRA, dearness allowance, medical allowance, conveyance, and commission, all in all totaling to 25,000 rupees, and it's a monthly salary. Now, what all can be excluded from these? Based on the second bucket that we saw in the definition, there are three components that can be taken out, namely HRA, conveyance, and commission, which means a total of 13,000 can be reduced from remuneration. Wait, is that really the case? Then how will the limit of 50% impact be working? So for that, we need to compute 50% of remuneration. So we saw in our example that the total salary is 25,000. So 50% of this will be 12,500. So if we compare this with the exclusions, which stands at 13,000, it is in excess by 500 rupees, which means we need to add back this 500, leaving us with a number at 13,000. And in our illustration, we do not have any benefits in kind. So wages would be 13,000 for the purposes of the new codes. Okay, so that wasn't very difficult. It was a simple structure. Let's see how it impacts the benefit entitlements. Say, for instance, gratuity. We'll take another case study where we have a total remuneration of 15 lakhs, including variable pay of 3 lakhs. So the annual CTC will be 12 lakhs, 40% of which goes towards basic. We have HRA at 40% of basic, or 1.92 lakhs. And there are other components such as LTA at 1 lakh, fuel reimbursement, employer contribution to PF, NPS contributions, etc. So if we have to compute wages, first under the Payment of Gratuity Act, here it was only basic salary because we don't have DA in the structure. So it would be 4.8 lakhs, while the amount under the Code on Social Security would be almost 1.5 times or more, and it stands at 8.7 lakhs. So how have we arrived at? This is by including the basic salary, then the meal vouchers, the special allowance, and the variable pay. Now, because the wages is higher, it will also result in a higher gratuity entitlement for qualifying employees, which means those who have put in 5 years of continuous service. Fixed-term employments are entitled to gratuity under the code. And therefore, if we add this cost, it will not be an exaggeration to say that companies may have to be prepared for a significant impact on their P&L. Now, while the code does not have any provision for retrospective applicability, we should not forget that gratuity is paid for past services, and to that extent, there could be a retroactive impact once the code becomes effective. In other words, when determining the gratuity payout under the Social Security Code, employers have to factor the service period prior to the date the code becomes effective. Now, we are hearing reports that the government could notify a two-step computation methodology for gratuity, the Payment of Gratuity Act, till the date goes live, and the other based on the new wage definition. If that were to be the case, then there will not be a retroactive impact. So that was a couple of illustrations on the wage definition and the impact on the entitlements. We'll now move on to the types of workforce covered by the codes and see how they would be impacted. Over to you, Anjali.
Thanks, Radhika. That's quite complicated, but probably with the time we will take it ahead. And now let's see that what kind of different categorization of workforce could be there, though we have discussed some in detail in the previous slides. But if we see the workforce categorization, these includes regular employees, fixed-term employees, and those under the contract as well. So regular employees are, just as the name suggests, that means a person who has been engaged, of course not the apprenticeship, who has been engaged by the establishment to do any kind of a work, whether it's skilled, semi-skilled, manual, operational, supervisory, etc., whether the terms of employment be it express or implied. They would be entitled for the various benefits as we saw under the Code on Social Security, such as PF, ESI, bonus, maternity benefit, leave encashment, etc., as per the applicability under the different codes. Then fixed term employment, which Radhika did mention that they will be now entitled to the gratuity, provided they are doing the similar work or same work as that of the permanent workers. And upon completion of period of 1 year, they will be entitled to the gratuity as well. And expatriate employees also entitled were the employees who has been sent on an engagement or an assignment to work for an affiliate in India and could be covered as well under the fixed term employment, since the arrangement is typically for a fixed period and less than for a period of 5 years. So, and also the foreign nationals who are directly employed by the Indian entity could also fall within this category if the period of employment is definite. As a result, employer need to take cognizance of the additional category of workforce being covered for gratuity and evaluate or factor the resulting cost impact as per the provisions of the code. Also being defined, and it means the worker who shall be deemed to be employed in connection with the work of an establishment, whether it is hired, when it is hired, he is hired through the contractor with or without the knowledge of the principal employer. Contract labor will also include the interstate migrant worker, but what it does not include is a worker who is regularly employed by the contractor for activity of his establishment, and he is getting the periodical increments, pay in the pay, the social security coverage, and other welfare benefits as well. As Radhika mentioned earlier, gig workers and platform workers are also being brought within the purview of the Social Security Code. These could comprise of individuals who work for an entity outside of an employment relationship and earn income. Consultant and retainers are a couple of examples who could be categorized as the gig workers. The code mentions mandatory registrations for the workers to be eligible for these benefits. The scheme per se is yet to be notified. So these are the broad category of the workforce one could relate to identify the impact. Saraswati,
thanks, Anjali. That was very comprehensive. Thank you so much. Well, that brings us to the second polling question of the day. And clearly this relates to wages. So the question is, what do you believe could be the impact of change in the definition of wages? First up is, of course, significant financial impact, minimal impact, no impact, not assessed, don't know, not applicable. And while we are waiting for the results to come in, Radhika, can you call out what do you believe are the areas of impact on account of the changed definition of wages?
Yeah, the definition, new definition, Saraswati, appears to be, the impact appears to be more wider when it comes to retirement benefits such as PF or gratuity as compared to the impact on, say, for instance, ESI or bonus. Now, the impact could be on the quantum or the coverage per se or both. When I say coverage, the number of employees or workers who are covered could undergo a change based on the new definition. If you take gratuity, there is definitely going to be an impact, since earlier only basic salary and DA was considered as to be the base on which you compute gratuity. Now it's going to be very different, as we just saw in the illustration. Further, you also have to factor the past service period, and to that extent also there could be an impact. From a PF perspective, I think companies would need to evaluate how it would impact for their specific situation. So on an overall basis, I think there would certainly be some amount of financial impact, and companies would have to see what it is for their given situation.
Well, Radhika, thanks for that and calling out the specific areas of impact. We do have the results on the screen, and as we are seeing, 65.2% of our participants feel that there is going to be a significant financial impact. About 10.9% feel that there's going to be a minimal financial impact. About 18% feel that they've not really assessed it. 5% feel they don't know. And what I'm happy to note is that nobody feels that there's going to be no impact. So clearly, this is, if I can call it, a very impactful legislation. Now, let us move over, and I'd like to invite Anjali to talk to us about the penal provisions under the various codes. Anjali?
Thanks, Saraswati. It's really important to us to understand that what kind of penal provisions could be there under the various codes for the purposes of non-compliances. So the penalty and prosecution implications outlined under the code have been aligned with the nature of offense being committed. So for example, if there is a failure to comply with the provisions relating to layoff or retrenchment of worker or closure of industry, that attracts a fine of rupees 10 lakhs. Similarly, a second offense in this relation can carry a fine up to 20 lakhs. It's not only the fine, there could be an imprisonment as well for a term of 6 months. The code also provides for compounding of offenses, though this cannot be done for an offense committed for the second time within 5 years from the date of commencement date of the first offense. Another violation where the penalty is not punished, with a fine which may go up to 3 lakhs. So the penalties, as we see, are linked to the nature of offense and the offense of serious nature, such as harming public at large while dealing with the hazardous substances. The penalties are not limited to the financial in nature. These are extended to the imprisonment as well. Clearly, there is a high level of compliance and governance process expected from the establishments.
Thanks, Anjali. So it's interesting to understand also that who would be within the organization would be considered responsible for non-compliances. Does the code call that out?
Yes, that's called it out in the codes, and let me elaborate a little bit on it. So if we talk about factory, the occupier is the principal person who would be held responsible for all the compliances. And if that be the case of mines, the owner, the agent, or the manager who is designated so shall be responsible. And any other establishment, the person who has the ultimate control over the affairs of the establishment shall be considered responsible for the compliances. Hope that clarifies, Saraswati.
Yes, it does, Anjali, and it also cautions us that we have to take the compliances requirements under the code very seriously. Now let us look at the focus areas for employers, because we've looked at what could be the areas of impact. We've looked at how the definition of wages is changing. We've looked at what are the compliance requirements under the industrial relation codes and the code on occupational safety, health and working conditions. So given that the implementation is just round the corner, let us look at what are the key areas which we believe companies should focus on. So as you can see on the screen, we've tried to compartmentalize into about 5 areas. And there is, of course, a lot of overlap in between. And the first one, to my mind, would be to analyze the impact of the change in definition of wages. And as I mentioned earlier, this can be achieved by mapping the components of pay of the company to the definition of wages. Not that the definition is very, very clear. There may be some positions companies need to take around it. And this should help companies to arrive at the impact from various perspectives, such as what is going to be the impact under PF, gratuity, coverage under ESI, bonus provisions. Is there going to be an impact on the take-home pay of the employees? Is there an opportunity to sort of minimize the impact by realigning the compensation structure? So it could be, the approach could be as simple as looking at reducing the flexibility under salary structure. Say, for instance, freeze the HRA component, freeze conveyance as a fixed component, as against providing flexibility for these. So even these kind of small steps could help in bringing more certainty to the definition of wages. And when there are changes in the compensation items and maybe a realigning of the compensation, companies in parallel will also need to look at change in policies as to whether Is there a need to realign the policy documents? From a PF perspective, what kind of call-outs are required to be there in the employment letter? If companies are not capping gratuity to 20 lakhs today, is there a need to cap that? Is there a need to realign the policies and the employee communications in parallel? What other policies need to be revisited? Say, for instance, from a working hour perspective, leave policy, overtime policy, no any other related HR policies, appointment letters. Anjani called it out specifically that there is a need to reissue these documents. What are the timelines for wage settlement? And because of the change in timelines for wage settlement, is there a need to re-look at the payroll processing timelines? What are the changes that is required in the retrenchment policy of the company? With the changes that is coming up, what kind of changes need to be provided from the medical examination facility that the organizations provide? All of these need to be re-looked at. And I think the other area of focus that companies should have is to look at the broader workforce. So, and Anjali did take us through the various categories of workforce, but I would say that for large organizations, this is an area that definitely needs to be emphasized. And a lot of the categorization needs to happen after reviewing the kind of activities that are taken up by these personnel, look at the kind of letters and the documents that are issued to them, and then determine whether they would fall beyond the regular workforce. Can they be categorized as fixed term employees? If we have consultants and returners, can they be categorized as gig workers? What kind of workforce would get covered under the contract labor definition? Because now the definition is very clear. And then after the categorization happens, employers would then be required to assess the compliance requirements. Are there any changes in compliance that is required? What kind of changes in documentation is required? So this is another area of importance which I would definitely like to highlight. And last but not the least, we put in being compliant, because this definitely is the whole objective. And to achieve this, it's important for corporates to understand the various provisions of the code, look at what are the changes in compliance, the timelines changes that is required, map the current compliance process to that is required under the codes, identify what are the areas of change, and of course, realign the internal processes to meet the compliance requirements under the code. So this is what I would like to keep as a key takeaways in terms of the approach that is required. Moving on to the last slide of the session. And I think it's important for us to understand this, because this is one question that we come across very frequently from organizations as to why should there be such a great focus on the changes under the labor codes when the implementation date of the code is not yet announced by the government. So in all our discussions with various stakeholders, be it with the ministry or with various industry bodies, and from what we are hearing from the public domain, what we keep hearing is that the government is on a fast track to implement the codes. And we know that while the final rules are yet to be released, the expectation is that the government is working on it and these will be released very soon. So why should corporates be looking at it now? Very clearly, all the 4 codes have received the presidential assent and they are acts today. And while the final rules are still pending, we do have the draft rules. There are significant action items that are arising out even from the provisions of the code. And this would help us to be better prepared and help us smoother transition to the codes as and when this become effective, because there are serious areas where companies need to focus on. We've talked about a lot of them: understanding what is wages, identifying financial implications, determining the change in compliances, identifying what are the touch points where process changes should be warranted. All these can be determined from the provisions of the code itself. And of course, there would be an catch up or a course correction that is required as we go through the final rules and the guidelines that come up. The stringent penalties which Anjali referred to, which are prescribed for non-compliance, and with the fact that there may not be a window period available to defer the implementation, these are things that are clearly worrying and should actually be spurring organizations to significant action that is required to be in a better state of preparedness. So that brings us to the end of the presentation. We have our final polling question for you. What do you believe is the key area of focus for your company based on the discussions that we've just concluded? Your options, as you can see on the screen, are review of salary structure and impact analysis, review of compliances and timelines, review of policies and processes, all of the above, do not know, not applicable. And while we are waiting for the results, I'm happy to share my take on this. And I do believe, based on conversations that we've been having with many corporates, also with the government authorities, that this is going to be a massive change for companies in terms of making sure that they are aligned on the compliances. So companies would need to look at all of these areas and much more. To my mind, labor compliances are something which is on top of all the corporates' minds. And hence, companies need to start focusing on all of this, what is there on the screen. To my mind, companies can possibly look at a step-by-step approach where looking at financial impact analysis could be a starting point. In parallel, understanding what are the changes in the codes also needs to be taken up by companies. And yes, the journey does not end with just looking at this. And as we can see on the screen, 83.9% of the participants do feel that all of these are focus areas. We see about 8.4% of the participants clearly calling out that review of salary structure and impact analysis is also a key area of focus for them. Review of policies and processes also seems to be another area of understanding. I'm surprised to see that review of compliances and timelines has got about 0% response. But I guess since it's covered in all of the above, it does mean that no, compliance timelines is also an area of focus. So that's come to the end of our today's discussions. But we do about 8 minutes to take some questions. So Atul, let me start with you. The first question is on, is it now mandatory for companies, including those in the IT and ITES space, to adopt the standing orders? Could you help with that, Atul?
Yeah, definitely, Saraswati. Even in past, there used to be a view standing order doesn't apply to the service industry. But considering the situation we have in hand and at present, standing order applies to both manufacturing as well as the service industry. And it is evident from the public domain when the government of India has put their draft standing order in public domain, they have put for service sector separately and manufacturing sector separately. That means the intention or the view which we used to take, it was correct. And now this applies to both service as well as manufacturing sector.
Right. Thanks, Atul. That was helpful. Let me move on to Anjali. Anjali, there is a question on leave encashment. So now, is it now mandatory for all employees under the Occupational Safety, Health and Working Conditions Code?
So, Saraswati, as we go through the codes, the OSH code specifically provide for the leave encashment to the workers. And there is a thin line of difference which has been created amongst the employees and the workers. So that's the distinction which need to be identified to determine the entitlement on the leave encashments.
Okay, right. That's helpful, Anjali. Radhika, I think there is one question that's come up on a Provident Fund. So is Provident Fund now mandatorily going to be made on the new definition of wages? And if yes, is it not going to be a double hit to the employee and the employer? Can you please respond to that?
Yes, Saraswati. Based on a plain reading, it does look like contributions have to be made on wages. However, we should also be mindful of the fact that the transition provisions do indicate that the schemes will be effective for a period of 1 year from the date the code goes live. And the wage ceiling beyond which it will be optional for employees to contribute to PF comes through the schemes. Therefore, companies will have to now evaluate whether they can continue contributing on basic salary as they are doing today, especially in the case of employees who are drawing salary in excess of this ceiling limit, because there the contributions, as I said, are going to be voluntary. So I hope that answers your questions.
Yeah, yes, I would agree, Radhika, given that
I
since...
can see one question and... Sorry.
Go ahead,
I could see
Radhika, go
one
ahead.
question, and if I could pose that to you. The question reads that the impact on account of gratuity is going to be very high where companies have not capped the gratuity to 20 lakhs. So can it be done now?
Well, Radhika, what I would feel is, yes, the statutory requirement is to pay gratuity up to 20 lakhs. And while this is a notification that has come under the existing Payment of Gratuity Act provisions, there is a specific para under transition provision which says that the existing notifications and all will continue to be valid until they are repealed. So my take would be yes, the 20 lakh ceiling is going to continue. The other question in terms of where it is not already capped, can it be capped now? I think companies, what I'm hearing is that there are various approaches that companies are taking onto this. Some of them are looking at whether for new employees alone, can I cap it? For existing employees, if they've already crossed the 20 lakh cap, then is it required for me to pay on the considered gratuity on new wages, or can I continue to calculate that as basic salary as was being done in the past? Can there be an option where I have a conversation with these employees and provide a one-time payout and then cap it across 20 lakhs? So there are various options that companies are looking at, and yes, it would need to be taken on a case-to-case basis. I do see that we are getting in more questions. There is one question, Radhika, and maybe you can pick it up. This is with respect to variable pay. There is a question on, does the definition of wages clearly call out how variable pay is to be treated?
Yes, Saraswati. If you see the definition per se, first of all, it starts with all remuneration. So clearly under that bucket, variable pay will have to be included. And then if we see whether we can bring it under the list of exclusions, unfortunately, it's a very, very specified list and it has only statutory bonus. So to my mind, as it stands today, variable pay cannot be excluded from the definition and it will form part of wages. In case there is a specific clarification, because there will be challenges if we have to include variable pay given the uncertainties revolving around it and also with the one-time components. So till we hear from the government of any clarifications on this aspect, I think it will have to be included as wages.
I agree, Radhika. And Atul, I'm seeing a question on in the absence of given the work from home arrangement, how to determine overtime, given the working hours and that. Any thoughts on that, Atul?
Yeah, definitely. Even if the work from home is going to be the reality going forward, of course, I would say, should not say going forward, it's already been the reality. The proper maintenance of the logbook and entry and exit time, or from the perspective of switching off and switching on of your laptop, could be considered as one of the element for the purpose of considering these kind of working hours, etc. And of course, in couple of organizations, we have seen there is a concept of logging hours in a timesheet. That could also be an additional triggering point or reference point for the purpose of finding out overtime, etc.
Right. Thanks, Atul. That's helpful. Maybe I can pick up one last question. There is one question on whether now wages need to be settled within a 2-day timeline for exit cases. The answer is yes. This is coming out from the payment of wages provisions which are subsumed under the codes. And these provisions earlier were applicable only to employees who were with income of 24,000 rupees or less. And now the income limit has been removed, which means it's applicable across the board. Thankfully, the word used is wages, so it would be wages as defined under the code, which still provides companies with some leeway in terms of calculating what is the total payment and settling. No, the final full and final settlement can be done maybe later. So yes, there are quite a few challenges that are coming up, and it's been a pleasure having all of you on the call today. Given that our time is up, a very big thanks to Atul, Anjali, and Radhika. Very thanks to all of you for the time taken, and a very special thanks to all the participants who've been able to join us and who've been raising so many questions to make this more interactive. We would like to encourage you to fill out the short survey that will pop up on your screen momentarily. And please do tell us what you think about today's program. If you did join us late, please note that this presentation will be archived for future viewing. If you feel that others would benefit from this webcast, please share the webcast via the share this icon or have them visit the debrief's website. We will respond to all the questions submitted during the webcast in about a couple of weeks. And please do not forget to tune into our next scheduled webcast from the transfer pricing series on 25th February, titled Parental Corporate Guarantee Changing Landscape. From all of us here at Deloitte, thank you so much for your participation in Deloitte Asia Pacific Tax Webcast today. Goodbye.